YouTube, it's Tone back with another one for you. So this one here is a continuation of cracking the code. This is number 9, the video, cracking the code 3, number 9. So here we're gonna get into what is it? The power of the common law. A little bit of that shit, the security agreement, and what it means to have it, and what constitutes filing. All right, so let's get into this shit here. This is good shit here too. Crucial information. So the power of the common law. Perfection by possession is a species of common law. So, they say possession is 9/10 of the law, right? So it's non-statutory and is effected with a simple statement at the top of a security agreement whereby the debtor acknowledges delivery of all such property in which a security interest can be perfected by possession into the hands of the secured party, cited in the previous paragraph. A common law lien is a species of lien defined as one known to or granted by the common law as distinguished from statutory, equitable, and maritime liens. It is a right extended to a person to retain that which is in his possession belonging to another until the demand or charge of the person in possession is paid or satisfied. So, thus, you have the non-statutory, non-judicial common law origin of your claim of right of possession of the negotiable documents, goods, instruments, money, tangible, shadow paper, and certified securities associated with your strawman or debtor's trade name, all caps trade name. You have a common law right for retaining possession of all such property until the obligation is satisfied, paid off by the debtor, your strawman, unless and until the obligation is satisfied in full. Neither the strawman nor anyone else may lawfully remove a single piece of any of their property, i.e. collateral, that has been delivered onto your secure party's possession. So, and that's the whole point of the lien. When you file your UCC1, you're saying that that they owe you X amount of dollars, and nobody can interfere with a contract that you have until your debt is paid in full. So if you put $100 million lien on your all capital strawman, nobody else can come in between you two and try to tax your fucking strawman until you, holding the superior claim, are paid in full. So they would have to pay you $100 million in order to even come in and tax your strawman. So anything up to that amount is basically going to be zeroed out because you are owed X amount of dollars. So nobody can come in between that. Okay, so that's how that works. So let's go to the next slide. So the common law is ancient and immutable, established by usage and customs since before recorded history. So basically, the fact that you are using it and you're the only one putting any energy into it and behind it, you're gonna go ahead and claim possession of it, right? Because you're the only one that's really using it and putting and adding any value. So as strange as it may seem, the common law is still in force and effect today. People just don't know it because they have been conned into believing it doesn't exist, courtesy of the Federal Reserve note, currency monopoly scheme, cabal, and unwittingly consent, surrender privacy, grant jurisdiction with virtually every single advance made against them by government and legal commercial predators. In fact, our impossibly complex legal judicial system and its billions of pages of codified law, including the UCC, have been developed over the last millennia by the creditors, money changers, for the express purpose of circumventing the protections afforded debtors by the common law through lexical trickery, deceit, and obfuscation. So the UCC is still the culmination of these efforts. However, despite the universal power of the UCC, it is still junior in the face of the common law, as attested by this excerpt from one of the world's most respected authorities on the UCC, Anderson and the Uniform Commercial Code 1981. So clause 1-1036 common law. The code is complementary to the common law, which remains in force except where displaced by the code. In attempting to codify a large body of law, it is almost impossible to anticipate all the factual situations that may arise. And it is for this reason that courts have adopted the principle of statutory construction, that a statute will not be construed so as to overrule a principle of established common law unless it is made plain by the act that such a change in the established law is intended. So basically, unless they can prove that you're operating in a commercial capacity, common law is going to go ahead and rule over all that shit. So a statute should be construed in harmony with the common law unless there is a clear legislative intent to abrogate the common law. Courts should be hesitant to improvise new remedies outside the already intricate scheme of Article 3 and 4. However, this new cause of action would not interfere with that scheme, but extend its principles to a situation not specifically foreseen by the drafters. The code cannot be read to preclude a common law action. So what they're saying is that they can't design a UCC code of statute that is in effect stating that it has any more force than the common law. So, but they like to word their shit close to that, but not really. So. Whereas any item of property that is registered in a public registration scheme with a government agency should be specifically identified in a security agreement. A description of all personal real property is sufficient whether or not it is specific. If it reasonably identifies what is described with a few minor exceptions. UCC 9-108. A properly done security agreement is vital for manifesting fiscal integrity, maintaining control of every single piece of property under the sun, moon, and stars that is considered private property of the trade name. That's why the security agreements, you see the video I did, One Man Out, UCC 3, the security agreement, check that shit out. That shit goes into super detail. You know, it doesn't leave anything out to the fucking imagination. So I did send mine to the Secretary of State privately just for them to see it, but not even to really, you know, keep it on file because it is essentially private. But I wanted them to see that I fucking did have one, and you know they don't really send you nothing back with that. But so I sent that along with some other documents that went along with the UCC one, you know, stuff that didn't fit on that page and all that shit too. So remember, the entire artificial person and solvent industrial community functioning as it does solely in the debt liability instruments, Federal Reserve notes, is incapable of establishing accounts and doing business with solvent sovereign creditors, only bankrupt subject debtors such as your all caps trade name, and of course the surety, the shadow sovereign, and his inferior degraded status associated therewith. So that was the guy that you were before you knew that you weren't him anymore. So you don't agree to be the surety for that thing so much as a authorized representative on behalf of it. You know what I mean? So the sample security agreement provided in the practical portion of this manual between John Henry Doe and all caps John Henry Doe is certainly many hundreds, if not thousands, of man hours in the making. Big Brother's legal experts will not be pleased with the soundness of this document. So pretty much the document is fucking bulletproof, right? And I mean, it's private at that, so it's not subject to any of their fucking concepts anyway, you know? So full realizations of its integrity and value will come only with earnest study, unless, of course, one simply begins using it as needed and observes the response of the legal professionals that are confronted with it. So, and common law is always gonna take the cake whenever it comes to anything in general. So that's something that you definitely gotta know there. Common law and contracts, those are the two different things there. So the UCC financing statement, perfecting legally establishing the security interest by filing. Besides perfecting by control, delivery, and possession as described above, the secured party can perfect the security interest in most types of collateral by filing. The UCC1 filing office is a public venue for the registration of notice of private contracts. Since the only legal tender currency in America is the private script of the Federal Reserve, all exchange of this so-called money has private implications. Hence, the advent of the pre-judicial and non-judicial, i.e. private UCC in 1954, and the UCC filing office, which keeps track of the ever-increasing stream of private contracts registered therein by those in the know, when Federal Reserve notes comprise the valuable consideration between the contracting parties. UCC filing offices provide a central forum where a creditor secured party can receive official governmental knowledge of the private contract between himself and a debtor, as well as an established seniority over the creditors based on the date and the time of filing. The foundational filing document is a simple form known as a UCC financing statement, formerly called a UCC1 financing statement, before July 2001, containing the name of the debtor, the name of the secured party, and a sufficient indication of the property pledged by the debtor as collateral in the transaction. See UCC 9502. The financing statement only puts third parties on notice of the secured party's perfected security interest in the debtor's collateral. The security agreement is what creates security interest and must be reasonably identified with and must reasonably identify the collateral described. Whereas financing statement can be general in description of the collateral. The security agreement must meet certain requirements, but the collateral indicated in the financing statement must match up with the collateral described in the security agreement for the effectiveness of either in securing the collateral. The financing statement and security agreement are complementary components. Neither is effective without the other, right? So you got to have your security agreement along with your UCC1, all right? Because what the fuck, because it's all about contracts, and so you can't put a lien on your all caps without having a contract with it. That's why anybody here that is putting liens on judges and cops and lawyers and shit, you're running into problems because you don't have your contract already in place. So when you send your estoppel over, or your notice of copyright and things like that to them, they're already agreeing to pay you prior to you even getting into any problems with them in the first place. That's the whole point of noticing them, so that way you already have a fucking legally binding, enforceable contract already in place. So if they get out of line at any point, you can go ahead and fucking lien them without having a problem, because you already fucking told them that you were going to do that. You know what I'm saying? And they didn't say nothing about it. So that means that they fucking agreed to it. Not like they even can say anything about it. They're all public servants. You know what I'm saying? So when you put them on notice to let them know that if they perform any fucking acts outside of their line of their limited delegated authority, then you're gonna go ahead and put a fucking lien on them ASAP, and it's payable within 10 days of when you send the fucking bill. You already have that contract in place. So when they act the fuck up, you just go ahead and place the lien on this, and this should not be a problem. You should be able to collect. You know what I'm saying? But if you don't have a contract, that's the whole point of having a security agreement or any contract in general with these people. Nothing is fucking effective unless there is a contract, because everything has to be a consensual contract, right? That's just the way that contract law works. So what this here is saying is that the security agreement is complementary components, and neither is effective without the other, right? So you got to have your security agreement already in place before you file the UCC1, and then maybe go ahead and notice them with that as well if you want, right? So there is no requirement that a copy of the security agreement be included with the filing of the UCC1 statement, only a sufficient indication of the collateral covered. The only requirement is that a security agreement be authenticated, i.e. signed by the debtor, right? So, I took it a step further and went ahead and just sent them a copy of it. It wasn't a big deal for me. So public filing versus privacy. When a secure party voluntarily makes public the intimate details of the private security agreement between secure party and debtor by including it in the filing financing statement of the UCC1 filing office, where anyone can easily obtain the information simply by paying for it, he or she foregoes any privacy protections afforded under the common law and the 4th article of the amendment of the Constitution. There is no compulsion for making the public the private contractual relationship between the secure party and the debtor. Therefore, it is recommended that the security agreement be only accurately identified in the UCC financing statement and not filed along with it. So, that's a choice for you to make. You know what I'm saying? So, but I mean, you can cover yourself a bunch of different ways too. You can go ahead and do your common law copyright, where you put it in the paper for 3 days running, and you go ahead and get your affidavit of publishing from the newspaper after they publish it, and that should suffice as to your standing in the common law copyright just in general, right? So here is a real life example from a December 31, 2001 article in the obituary section of the Los Angeles Times, revealing the liabilities that come with voluntarily placing private information in the public record. Hamilton had created notoriety by himself by writing an unauthorized biography of J.D. Salinger called J.D. Salinger, a Writing Life. Salinger opposed the publication of the book for several reasons, but the only line of attack was by suing Hamilton's use of Salinger's common law copyrighted material for commercial gain. Insertion of about 70 of Salinger's private letters. So what is it? So it says Salinger's private rights, common law copyrighted material, was just that until Salinger voluntarily made it part of the public record by entering it into the lawsuit. Salinger successfully stopped publication of Hamilton's original handbook, because it contained letters challengers common law copyrighted property, but officially placed it into the public domain with the very information that he wished to keep confidential. So what it's saying is that if you have something that you really don't want out in the public, then don't fucking put it out in the public. If it's a book that you haven't yet fucking published, you know, by filing it on the record to, you know, to show people that you do have a common law copyright on it and shit, is pretty much giving it away, because then anybody can access it at that point. So that's what that's saying right there. So you just got to be careful about how you are entering any of this information into the public if you do that. So the sample security agreement in this handbook is designed for keeping private as much information as possible and need not be publicly filed along with the financing statement, merely authenticated, signed by the debtor. The security agreement is also believed legally impregnable by third parties, and a redemptor who understands and knows the proper use of this document can begin to enjoy the profound benefits associated with its use. Financing statement is defined as a record of records composed of an initial financing statement and any filed record relating to the initial financing statement. So you get your reference number and shit like that too as soon as you file it. So modifications, changes, and adjustments of the original financing statement are implemented in what is called a UCC financing statement amendment, formerly called UCC 3. In most jurisdictions, and a UCC 2 in others, as revealed in the definition of financing statements above. Any subsequent related UCC financing statement amendment filed qualifies as any filed record relating to the initial financing statement. Any amendment is absorbed by and automatically becomes part of it by the original financing statement. So anything that you want to add, any information, if you need to update information and things of that nature, then you go ahead and file that with a UCC 3. So publishing of a notice of common law copyright. Read the straw man's trade name mark establishes common law control of the trade name. The debtor in the relationship filing at the county recorder's office further solidifies the ownership of the common law copyright. The foundational contractual document between debtor and creditor is called the private agreement and evidences the commercial agreement and the rights, duties by, and between the parties in the mutually beneficial, consensual commercial transaction. The debtor indemnifies the creditor in the hold harmless and indemnity agreement, and the legal distinction between the two is made clear. The creditor establishes a bona fide claim called a security interest equivalent of a lien in the property pledged by the debtor as collateral by giving valuable consideration. The security agreement is a document authenticated minimally by the debtor and contains a description of the collateral that secures the indebtedness in favor of the creditor, who is now called the secured party. When the debtor authenticates the security agreement and the security interest attaches, becomes an enforceable contract. So you got to have the security agreement, and so it's looking like here without it you can't really you can't enforce the contract without it being a contract. And really, I mean, if you plan on trying to enforce it in any of these courts, you got to understand that all these courts are commercial courts by nature, and they only deal with contracts. So, you know, until you have your contract in place, you really don't have any claim, and it's not really going to line up with the jurisdiction or the realm that these courts operate under, right? So, except for a few types of collateral, when the secured party files a UCC financing statement and references an existing authenticated security agreement therein, the secured party security interest in the collateral is considered perfected, legally established. Generally, the earlier date and time of filing determines priority in the debtor's collateral between competing creditors. So it's like, you know, first in line, first in time. And that's how that shit goes. So, or first in time, first in line. That's what it is. So, you know, the primary superior lien holder is going to be the one that has the lien on everything first. And then anything after that is going to be secondary, and you can't get paid until the first guy does get paid in full. So any desired changes in a financing statement are effected using the UCC financing statement amendment, which becomes part of the original financing statement upon filing. So anything that you file with the UCC 3 essentially is becoming part of the UCC 1, and it's all going to be legally binding at that point. So you guys got to understand contract law. That's how you win this fucking game. It's a game of chess. Stop playing checkers with these assholes. That's what I got for you for now. Until we